Yeah, there you go. Hey, everybody. You've got me and Kerry Baker back. I know everybody's so excited. Welcome to this week's YouTube Live. Kerry, you just ready to get into it?
Sure. How are you doing?
We're good. All right, let's go, Nate. We're ready.
You want to start or you want me to start?
I'll start. Okay. This is from Chris. The YouTube opinion in the M21 change made things harder. In Spicer v. McDonough requires a standard of but-for causation, and that is stricter proximate causation standard is inconsistent with the statute. In accordance with the Spicer holding, the Department of Veterans Affairs will apply the broader but-for standard and will no longer consider natural progressives of non-service connected disabilities when deciding a claim based on aggravation of a non-service connected disability by a service connected disability. I'm hoping you could put minds at ease. I'm guessing that's the end of it. All right, so in all honesty, Spicer v. McDonough was actually put out a while ago. This is not new case law. This is something that VA, when things are going to the board, that is the standard they've been using for secondary service connection. I haven't found it to be more limiting than the other one. It's just another way of kind of framing the issues, and it still allows for secondary service connection, A led to B, A aggravated B. It's broader, which I think helps a little bit more, to be honest with you, but it's been in the works and we've been using this kind of language and Spicer for literally years at this point. The M21 takes a really long time to get the case law as it comes down from the court system to be implemented and put in to the M21. Now that it just recently went into the M21, even though it's been the law for quite some time, what I don't know now is how the regional office is going to decide these claims now. And if the way that they put it in there, it could make things a little wonky, but based on my experience in secondary service connection, it's not going to be harder to get secondary service connection at all. Kerry, do you have anything to add on that?
I think that was a really good explanation. I'll just add that keep in mind that it cannot eliminate the benefit of the doubt standard of service connection, whether you're talking about secondary or anything else. It can't replace that, and it doesn't replace that. That's still grounded in statute and regulation on any material fact relevant to the outcome of a case, that you just have to show equipoise level evidence. So to the extent that some people feel that, that case elevates that, I would disagree. I don't think it does, because it cannot change the standard of service connection. So it's just, to me, it's more semantics, that I've seen it applied in a broader fashion where it actually helped, almost like it relaxed the standard a bit. So, but it doesn't matter. At the end of the day, in your average everyday claim, they apply, cause and effect analysis and all kinds of things that, in my opinion, absolutely violates the statute, the benefit of the doubt standard. So without even getting into the but for. causation.
Yeah. And thanks for letting us know. Like, so, people are very concerned about it. I really don't think that you need to be that concerned about it, not from a practical standpoint like we've seen it. All right, you're up, Kerry. You're next.
All right. I'm a sorry. I'm a female veteran rated 90% with a pending increase for PTSD, depression, and migraines. My low back was previously denied, but my neck was never submitted. I attended airborne school. I now have a cervical MRI showing multi-level degenerative disc disease, severe foraminal stenosis at C3 and 4, C4 and 5, causing spinal stenosis and possible myelopathy. Should I file the neck as a new claim and the low back as a supplemental claim now, or wait until my pending increase is decided? Look, that's that's really a personal choice. If you're going to file, yeah, you would have to do the neck as a new claim and the back as a supplemental, simply because the neck's never been claimed and the back has. So just the mechanism of doing the filing, yeah, that's what you want to do. Do you have to wait till your other one's decided? No, you don't. Some belief out there that, don't rock the boat with too many things. From what we just read off there, you don't have too many things going on. I would say you're probably perfectly fine in filing now. That's different than getting a dozen things going at once, or half of them aren't going to help you. Here, sounds like if you can get the neck service connected, sounds like it will help you for sure. So I'd probably go ahead and file, just because there's no real reason to wait.
All right, Cecile Dixon. Hello, I'm at 93 total, round down to 90, 70% for mental health, 30 for migraines, 10 for GERD, and lots of other 10 and 20% ratings. I put in an intent to file in January, which I did file IBS and got 0% connection. My decision letter said not too much impact. Should I start building impact log and go off into the doc for IBS, then do a supplemental claim, or just go for an increase in migraines 30 to 50? I did an intent to file already, and the very next day after original claim. It's 3 months apart from the previous intent to file. I have enough record for migraines increase. Don't want to lose 3 months. Is that the end of it? Okay. So if you're 93 you really just need to get to 95, which is additional 20%. You know, if your migraines are severe enough to where you have, prostrating attacks that make you lay down, you're missing work because of it and things like that, and you think that you meet that criteria, I would certainly file for an increase in those migraines. Can you go back to the beginning? I kind of forgot part of it. Oh, to do the IBS increase. Okay. I mean, I think, you need to go with whatever is in your file that is indicative of the higher rating. If you think that you got too low of a rating for the IBS and you want it to get higher, certainly keeping a log, going to the doctor, and then refiling, filing for an increased rating is certainly something you can do. You also may be able to just do the migraines. As far as the intent to files that I know that you talked about, do be careful, because I know you said you put in an intent to file, then later you put in another intent to file. Um, Once you put in a claim, you can't stack up those intent to files. Like, you can't put in one every month and then say, well, this claim went to that one, this one went to that one. You can take the one as far back, but you don't get to keep those other ones and then file additional claims to kind of go back on them. So whatever you're going to do make sure that you're filing either or file both. File for the increase by a supplemental and, reopen well, you have to file a 526 for the migraines if they're not on appeal anymore. But do those on the same day for whatever it is you choose to do, just so that you don't lose the intent to file effective date because you file one the next day. I think I answered the question. Kerry, did I miss something?
I think you answered the question. Angel Marrero. Mr. Marrero, how you doing? Greetings as we near the second half of 2026. What time frame are you seeing the BVA deciding direct reviews? Thank you. I don't think it's really changed from the first half. I'm seeing them in, I'd say, 8 to 12 months, give or take. Some, I'd say 8 is probably a pretty quick one. But within a year, would you say, Ursula?
I would say I haven't noticed the pattern on when we're getting them in 8 to 12 months or when I'm getting them in 2 years. Like, there's ones that we filed before that we're still waiting on decisions. So it's still very, very inconsistent. But I do feel like they're coming faster than they were last year or the year before.
Yeah, they've certainly sped up from a few years back. They were 2.5, 3 years back. I've noticed a number of them within a year. I just haven't noticed them get any faster than that unless it's an advanced on the docket case in the past few months. So, but are they going to stay at that? Your guess is as good as ours. I know the legacy appeals are taking just forever for the ones.
I don't think anybody working on them. Like, they should be going faster, but we still have legacy appeals waiting.
There's a good 30,000 or so legacy appeals that it's like it's not even a priority to them anymore.
But something to do, if you haven't already done it, to kind of speed things up is when you get your docketing letter, they're going to send this waiver that's on the back page. You can sign that and send that in. And what that does is you're waiving your right to be able to switch dockets. So if you have from the decision date, you have up until a year to file an appeal or to switch appeal lanes. And if you fill out that waiver, you're kind of saying, hey, I don't want to wait an entire year. Go ahead and make my decision now. So you could always send that in if you're still within a year of your rating decision. Another step. What information is available regarding the Camp Lejeune cases? I've been asked to provide a lay statement for my father's case, and I want to provide the best information. There's a bunch of information all over the place for Camp Lejeune cases. If you're talking for VA disability, and kind of what we work in, that's going to be there's going to be presumptive conditions based to that exposure that he had there. If you're talking about the Camp Lejeune litigation, that's different to what we're doing, that I wouldn't know. And it depends on what information they're needing in it. So I from that, I don't really know what to tell you to put in there. I mean, if he's been exposed, there's presumptive things.
Yeah, no, me neither. Michael Hawkins, 1 of 4. I have an appeal with the BVA for denial of aid and attendance. The RO, DRO, and HLR, DRO and HLR are the same, by the way, denied my claim because I don't have a single 100% rating. That sounds familiar. Even with the favorable findings from the DO, DRO, and HLR for the ANA. That sounds familiar too. I have 3 separate 2680s from my doctor stating I require ANA. I hope the board grants my appeal based on CUEs committed by the RO, DRO, and HLR. The initial claim was filed 2012, denied 2013. I filed the NOD within a year of that denial. In 2015, it was denied by the DRO. In 2025, a new claim for ANA was denied. Okay, oh, I thought that was for. Immediately filed HLR and denied in 2026 with favorable findings for ANA and housebound. I did file direct review with BVA. Can the BVA grant appeal back to 2012 based on CUEs? No. Okay. Let me back up on the second one there. You said CUEs. So you've got a direct appeal on the merits pending at the board. That is not the same as having a motion for revision based on CUE pending at the board. So you are appealing your case without having to raise the bar significantly to a CUE standard. All right. So you just have a regular appeal pending at the board from what I just read. Odds are if the RO made favorable findings, you need ANA, odds are the board's going to grant that. The board understands those findings are binding on VA. The ROs, and I'm including DROs in the ROs, half the time they don't understand what the hell is binding on them, which is why they have denied the claim for not having a single 100%. As far as the 2012 claim, it does not sound like that would get addressed at this point. If your current claim only goes from go to slide 3 or question 3, Nate. Let's see, in 2025, a new claim. So odds are they will only go to 2025. If you wanted to challenge the one from earlier, you would need to file a motion for revision based on CUE and start with the regional office on that. The regional office is obviously going to deny that. But until they do that, the board doesn't have jurisdiction to address the CUE in the first instance. So that's how you'd have to go about doing that. Now, the problem with that is if they did not make any favorable findings in 2012, 2013, and I'm sure they did not because they weren't required to. The AMA required them to do that. Prior to the AMA coming in effect in 2019, there was no requirement. So you'd be facing an uphill battle getting them to declare CUEs in the initial denials from 2012 and 2013. Not that it couldn't be done. I don't know the facts of the case. There's always that possibility, but just based on procedural issues that I see here, I wouldn't expect that. But either way, you'd have to start that claim fresh at the RO. So hopefully that answers everything. Anything, Ursula?
Nope, you got it all. Leander Savoy. Hello, I've been waiting for 9 weeks since I put in my higher level review for effective dates. How long does it usually take? How long have you gotten your higher level review back? Trying to be patient as I can. Thanks again. So I think it depends on what regional office or DRO gets it on how long it's taking for that's when we're scheduling conferences. So if you just filed a regular higher level review, 9 weeks is not a long time to wait. I would say be patient until about 6 months. After 6 months, you'd want to make sure that it's still pending, that it is somewhere and someone still has it and they didn't just close it out. But I think 9 weeks is just a little too early to start really worrying about whether or not they're going to do anything with it. So be patient. I know it sucks. Wait 6 months and then start getting a little more antsy.
Yeah, I've seen them averaging about 4 to 5 months. But that's, you got some sooner and some take longer. The Veterans Aid. If a veteran is denied PTSD due to an inability to verify stressor, could they then apply for their already diagnosed major depressive disorder? If so, what would be the new claim or supplemental? So yes, you can do that. It's better to file a claim. I mean, sounds like it might be too late here, but it's better to file a claim for service connection of a psychiatric disability to include PTSD, anxiety, depressive disorder. That way you catch all of the potential diagnoses in one shot. Okay. And in this one, it kind of depends. If you were specific for PTSD, one, did they consider the major depressive disorder in that denial? There's a chance they did. If they did not, I hate to say it depends on who gets that claim. Some are going to look at it. If you do it on a 526 as a new claim, they're going to go, oh, well, that you need they're going to send you out a rejection letter, tell you to file a 0995 because you've already filed for a mental health disability that was denied. Other people are going to look at that same claim if you did it on a 0995 and go, oh, you should have done it on a 526. You haven't filed for depression, you filed for PTSD. So it's a catch-22 sometimes. What I would probably do is try it on a supplemental claim and indicate that you're filing for, like I said earlier, psychiatric disability to include all these things, then parentheses, previously claimed as PTSD. That way,
Okay, so I was wondering if I was lost or if Kerry got lost. Um, but so what I would say, I agree with everything Kerry's saying. Just recategorize that claim as an acquired psychiatric disorder to include XYZ. And that's probably going to be your best way to do it through supplemental claims. And hopefully we get Kerry back. Otherwise, it's going to be me. Okay, well, welcome to Tactical Teachings. Today I want to talk about reductions. So I had previously talked about severance, where if your benefits are severed, what VA needs to prove and what you need to do and how to kind of overcome that. So today I want to talk about reductions. So a reduction is when you have been given a disability rating and VA tries to reduce that. So let's say you were rated at 50% for your PTSD. VA comes in and they say, we think it's gotten better. I want to reduce the PTSD to 50%, or you're back from 40 to 20, or whatever disability it might be. So when you get one of these letters that's proposing to reduce, I kind of want to go through and tell you what things are important to look at and what you need to do, and then also give you some things that might help you in trying to fight a reduction. So what VA has to prove when you're given a reduction or a proposal to reduce is they have to show that your condition has actually improved. And that's something that VA has to prove. That's not on you to prove. They have to say, okay, based on this evidence, we think that your condition has actually improved. They have to show that it got better. But there's a couple of protections that you guys have that I want to talk about, and then let you know what VA's burden is to prove that it's better, and then also just walk you through what happens when you get the reduction letter. So there's a couple of protections. So there's the pre-stabilization. And what that means is when you've had a disability for 5 years or less, so under 5 years, you've had this disability, what does VA have to prove? They have to prove actual improvement. What that means is that you didn't just go to one C&P exam and then that exam was less favorable than your others and they can now reduce you. So it can't be based on one exam, one person's, you know, thought that maybe your disability isn't as severe as it was rated prior. They have to do actual improvement over a sustained period of time. Okay. So when you get these types of reduction letters and you haven't been service connected for 5 years, most of the time what I see that's from is from um, getting a new exam, like you're trying to go for an increase or you're filing for unemployability or you're trying to get a secondary condition and they call you in for an exam and that one examiner is less favorable than what your record shows. And from there, you may get the proposal to reduce. So that's kind of what we see with those. There's also a 5-year rule. So that 5-year rule is if you have been service connected for 5 years or more, they kind of consider that stabilized. And VA has to then, it becomes harder for VA to take that away once that disability has stabilized. What they really need to see there is sustained improvement, meaning over the course of years, it has gotten better. And there's also another thing in there that they call sustained improvement under the ordinary conditions of life. And what that means is, let's say, for example, you have a back condition. And because of that back condition and all of its residuals, you're no longer working because of it. So they give you, high ratings for it. But now that you're no longer working, your back condition kind of gets better. Like it actually is a better back condition because you're no longer having to put the stress on your body because you've been given this benefit that VA has. They would have to show that if you were to go back to work, would your back still be still be doing well without without that reduction. So it's really hard for them to prove that. So it's under the ordinary conditions of life, is the sustained improvement. Again, here, one exam is not enough. It has to kind of be shown through all of your medical records, multiple exams. Sometimes you'll see them kind of prepping for a reduction. In cases like this, I've seen rating decision that says, although we see some improvement in your condition, we're going to continue your rating at XYZ. What that is, that's a cue for you to go, hold on, wait a minute. If I get another exam that is still favorable, they're going to be able to show sustained improvement and they may go ahead and reduce. So do keep an eye out for that. There's also a 20-year rule. So what this means is if you've been stabilized and your rating has maintained 10% for more than 20 years, they can't reduce you beyond that. You see this for people who may have gotten benefits. Let's say you got migraines right when you got out of the service and they were rated at 30%. You file for TDIU 30 years later, they come in and they're like, we're going to reduce your migraines from 30 to 0%. They can't do that if it's been service connected and rated at 30% for the whole time. And so it's important to look at when you were service connected from to find out how protected you are with that. Another protection is if you are 100% service connected for a condition. So for VA to take away 100% rating, they have to show material improvement. So some improvement is not material improvement. It has to mean that you are no longer unemployable, you are no longer severe, it's very difficult. Material improvement is also a pretty high burden for VA to be able to get to. And if it's something where, you were rated at 100 and they want to drop you down to 60, from there, they also then need to look at unemployability and say, well, we're going to drop him or her from 100. Is he or she still able to work due to that need? The answer is no. They need to at least put you TDIU for that condition. So those are kind of the protections. You've got the 5-year rule, the 20-year rule, and the 100% ratings with, the TDIU kind of worked in there. There is this idea that there's a 55-year-old rule. I want to give caution to that. There is a rule at VA that says that once you're 55 or older, they may not schedule exams for conditions unless there's certain circumstances, which means that if you file for something secondary or anything, VA can and will schedule you for exams that will open you up to possibly reductions. And they can open up and schedule exams. And if they do, and you don't attend, they can then reduce you from that. So I say that 55-year-old rule with a lot of caution. It's not really a rule because VA a lot of times will schedule exams even if you're over 55. Reductions of TDIU, they have to be able to prove that you can actually go back to work. And so that is another one that's very, very difficult. Again, none of this can be done just on one exam, and that's probably the most common type of reduction that we see. There's another type of reduction called a statutory reduction. Not really going to go into that today because that's something that happens because of the rating schedule, but there is another way that VA can reduce, and it's based on certain conditions that's written into the rating schedule that you will be reevaluated in 6 months, and then from there they'll go through and they'll go through and rate you after that. So that's a little bit different. But what should you do? So let's say you get a reduction letter. The way it usually happens is first you're going to see it in your rating decision. There's going to be a we propose to reduce this based on this. Then in the rating decision, it's going to give you information on why. Sometimes it's very vague. We've noticed an improvement in your condition, something like that. In addition to that proposed reduction in the rating decision, you will also get a separate notice of action. And on that notice of action, it's going to say again, we are proposing to reduce, and there's going to be a lot of information on that letter. Read that letter and pay attention to the deadlines VA has given you. So important deadlines to remember is 30 days and 60 days. So once you get that letter, you have 30 days to request a hearing. You can request a hearing on that reduction where you can then have a predetermination hearing with someone and say, look, don't take this away. It's not better. That was one exam. Here's all my evidence to show that I shouldn't be reduced. So you can get that hearing. And typically you have 60 days to submit additional evidence of why you shouldn't be reduced. Sometimes that's just sending in some medical records, pointing to medical records, sending in a lay statement saying, this actually has not improved. And remember, I said the burden is on VA to prove that it has. So any information you have on there that shows that it hasn't actually improved is just going to help you. So 30 days to request a hearing, 60 days to get additional evidence in to try to stop that reduction. You may get scheduled for more exams after you put in paperwork for the reduction. If that happens, do attend them and go and then see what happens from there. Now, let's say your reduction goes through. either you didn't know to do all this stuff or you do all this stuff and they still reduce you. You have the same appellate rights on that as you do with any other decision. So from there, you can take that decision or that letter that reduced you. You can file a higher level review. You can file a supplemental claim, and you can file to the board. My recommendation is I would go to the board for a severance, but keep in mind what you're not asking for is an increased rating at this point. If they have done a reduction on you, you're not trying to get an increase in that. What you're doing is fighting the reduction. So you want to say, I disagree with the reduction that happened, not you want an increased rating. VA will probably come back after you file your appeal and they're going to give you a rating decision that says increased rating denied. You can still take that decision that denied an increased rating, even though you said the reduction was improper, and appeal that to the board and say, I'm fighting the reduction. The board will be able to figure that out. And so, don't panic. It doesn't, if you get one of these letters, it doesn't mean you will be reduced. It just means that you've got a couple of things you need to do to get the right amount of evidence into the file that shows that you actually have not improved. And one bad exam is not enough for VA to take those benefits away from you. And that's it. That's what I got on reduction. That was a lot. That was a lot. And I felt myself kind of going over myself, but that's okay.
Well, it sounded good. I heard most of it. I bleeped out there for a moment. My power went bye-bye.
Well, we're glad you're back.
And
Let's
it
get into it.
came right back on, and my internet had to spin back up first. So
Okay.
I will take this one since you just said a whole lot there. Holland Love. Happy Tuesday. Happy Tuesday to you. When trying to get service connected for MST, what can be done to prove that the incident happened? If there is no record of an assault in your file, any circumstantial evidence that may be helpful. All right, first, you're not trying to get service connected for MST, you're trying to get service connected for a disability caused from MST. I know it sounds petty, but you don't want to claim it quite like that. They may go, well, MST is not a disability. So how do you prove that? Well, there's lots of ways to prove it. And a lot of it's listed in the regulations. You look at your service. What happened after the MST? Now, if probably worst case scenario, if the MST occurred and your service continued on with no change whatsoever, and you got out to regular date of discharge, you're going to have a hard time proving the MST. That's when you're going to want to get lay statements and something to circumvent the fact that nothing changed in your file. But most cases, once an MST occurs, that's a hugely traumatic event, whether you're a male or a female. Something's going to change in your service. Your proficiency in conduct is going to go down. You are going to go to sick call more. You're going to be late more. You're going to request changes in duty stations. All of those things are what VA considers markers. Okay. And so VA is taught that when somebody claims they have mental health disability related to MST,
Uh-oh, did we lose him again? Okay, I will finish Kerry's thought as best I can. So he was saying they're going to look at those markers. So markers are essentially that circumstantial evidence that happens during your service. Um, so you would want to make sure you go through your service records, your service medical records, and see things that would have changed after that stressful event in service. We see service medical records sometimes, all those things Kerry talked about, changing duty stations, just a drop off of a I just blanked out, sorry. A drop off of the way that you were performing in the military. So look at those things. VA will usually ask for a medical opinion where they will say, were these markers or the things that you point out indicative that an MST happened? And then it's going to be up to that medical provider to say, yes, these things look like they would be markers for an
Mhm.
MST occurring. So I try to finish your thought. I don't know if I did that or not, but
I'm sure you did. I apologize. I guess my internet is now a little unstable because of that power fluctuation.
all right,
Hope,
let's go to the
hopefully,
next one. I think we're done on this
hopefully it
one.
stays. All right, let me take it.
Yep.
All right, happiness. CMP exam for ankle gout Friday. Hubby has systemic gout affecting toe, ankle, pinky toe. Should we write a statement to clarify all? Confused to why only ankle? Rated for eczema, which can trigger too. All right, so lay statements are always, in my opinion, good and helpful. So I would write one. You may need it, you may not need it. I don't know why just the ankle versus everything else. It probably, I suspect that they're probably going to include the whole foot in that evaluation. That would be my guess, because some of the DBQs can cover the ankle and the foot, the toes, and the whole 9 yards. And they're probably just saying gout of the particular lower extremity. That's what I would guess. So I would expect that they would address everything. But just to be safe, I would go ahead and do a lay statement. How does it affect your husband? What kind of medicine does he take? How much pain is he in? What kind of limitations does it impose on him? All of that could be helpful, both to the examiner and the rater. You can always give the statement directly to the examiner, but even if you do that, still upload it to your VA file, because the examiner is likely not going to do that. They sometimes do, but don't trust them for that. So yeah, I would go ahead and do that.
Lincoln Kane, should I file, I'm guessing, a higher level review, and should I be at R1 because PTSD is why I got aid and attendance only? There is not enough information here for me to figure out anything. I'm really sorry. I wish I could help you, but there are ways to get to R1 when you have aid and attendance. But I'm sorry.
If I could add something, and there's probably more to your claim. I agree with Ursula.
Yeah.
There's definitely not enough here, but hypothetically, if PTSD is your only disability and you're at A&A for it, I would say you're probably maxed out. You're not going to get to R1 for PTSD only. Hypothetically, again, if that's your only service-connected condition, not going to happen. You can't get to SMCO with PTSD only. And if you can't get to O, you can't get to R1. But it could be half of the equation if there are other disabilities that we don't know about. The fatty fat guy for SMCT. I like that name. For SMCT, it requires an opinion from an examiner about the level of care absent regular A&A. I don't know about that. Unless the VA explicitly asks an examiner to address the hypothetical, the VA rater cannot make their own opinion decision regarding the hypothetical based on the review of the evidence, right? All right, I'm a little confused with how that's worded. All right, go back to the first one.
So first, SMC takes away that higher level of care that's required for R1 and R2.
Well, first though, your first sentence there is what gets me. It says requires an opinion from an examiner about the level of care absent regular ANA. Okay, it does require evidence that without ANA, you would need to be institutionalized. Okay. If you don't have the regular ANA, you're not going to get the SMCT, and that may not be what you're saying there. So I might be reading that wrong. But ANA, regular ANA, is absolutely a requirement for SMCT. It's right in the statute. But does it go? I don't mean to cut you off there, Ursula. To the extent that you saying it has to come from an examiner, I don't know about that. I don't think it has to. But at the same time, the rater can't make their own medical opinion if that's what you're suggesting. They can't do that. What were you saying again, Ursula?
I mean, I was just, saying kind of it's not the same higher level of care that's required. You kind of talked about that with the R1, getting to L and all of that. You are going to need someone, a medical person, to say absent this aid and attendance that they're receiving, they would require institutional care. That is a medical opinion and a medical question. If they send it out for a medical opinion and the examiner doesn't address that opinion and that's what they've asked for, that's an inadequate opinion, and VA should then ask the right questions and get an answer to the question that they're looking for. So, I mean, if you've had an exam opinion go out and they wouldn't address it, VA has a duty to assist you in getting those questions answered, and they should. The examiners can't just go, I'm not addressing that, and then VA can't be like, well, he didn't address it, so I'm going to go ahead and deny it. They can't do that. So
they usually do.
they do that, but
Yeah.
they can't. They're not allowed to. So you may just want to file a higher level review and say, we need a medical opinion to discuss this if you can't get your own in the record. And if you can get your own in the record, you can, hang on to that and file appeals based on that.
Yeah, if you can show them that they asked the examiner and the examiner did not answer, then an HLR will almost always send that back and tell them to answer the question.
All right. John Griswold, 3 years ago, with the aid and its incredible staff at H&P, I was awarded 80% permanent and total unemployable service connected from chemical exposure during the Vietnam era. Excellent. I was told by your staff that it might be possible to go back to 95 when I was rushed into surgery for an inflamed heart requiring open heart surgery. They suggested I wait a few years before attempting. I'm still battling my heart issues, having 4 cardioversions and an ablation since my approved claim. These issues are a direct result from open heart surgery. Would this be worth pursuing? So my suggestion to you would be to contact the attorney here at Hill and Ponton that originally worked on your claim. They're going to know the most about it. And if there are notes in there that said we would look at this at another time, they will have that information. So go ahead and give the office a call and talk to the case manager assigned to the attorney that you are using. If that attorney is no longer here, most of us are still here, but if there is one that's not, it can get sent to another attorney where we could review the file and take a look at what's going on. So I would defer to your attorney on what their thoughts are on that.
Okay, first I'd like to say I'm a little sad. I don't get the 2 Baker's block. There's a risk I might freeze in the middle of it with my internet connection being sketchy, and I was kind of looking forward to it.
No, we'll get it next time.
Oh, now Nate says that we can go for it if I want.
Go for it. Let's do it. Let's do it. Baker's block. I'll
All right, let's talk about reductions and hope my internet stays somewhat stable. I hope the Board of Veterans Appeals is listening. I know you're probably not. And I certainly hope ROs and DROs are listening. And I know that's probably a big ask as well. I want to talk about 3 things on reductions. All right, ROs, do you pay attention to how many times the Board of Veterans Appeals reverses your reductions? I know in our cases, it's nearly 100% of the time. Do you think you might be doing something wrong if they are reversing your reductions almost 100% of the time? There's really just one phrase you need to let sink into your head. It is sustained material improvement that is reasonably certain to continue under the ordinary conditions of life and work. That's it. That is the phrase, the standard that the board uses to reverse the most of your decisions. That the evidence does not show sustained material improvement that is reasonably certain to continue under the ordinary conditions of life and work. Because if you haven't shown that, you cannot reduce. That gets me to my next topic. You're not rating the case when you're reducing somebody. Right? You're not doing it for the first time. You got to keep in mind these completely crappy DBQs that you're looking at. I'll give you an example. A heart condition. Well, let's take headaches. We see this not all the time, but frequently with headaches. Vet's rated 30%. He's trying to get rated for 50%. Goes in for an exam. The examiner, you find out later, after marking that the veteran does not get prostrating attacks at all, which is usually going to get you reduced, did not ask the veteran if he had prostrating attacks. Moreover, yeah, you asked the veteran, you know what prostrating means? He's got no clue what prostrating means because the examiner didn't ask him. The examiner didn't explain it. Hey, do you get headaches that completely lay you out? You have to go into a dark room and lay down. Oh yeah, I get 2 or 3 of those a week. That's a prostrating headache attack. But that's also a medical term that most laymen don't know. Right? You go in for a heart exam, vet's at 60%. You can't walk across the room without getting winded. The examiner comes back and says, he's got a 7 to 10 METs. You ask the vet, hey, did the examiner ask you how much you can do before you get winded? No, they didn't ask me anything like that. Then how do you know it's 7 to 10 METs when all the other previous exams show the METs are 3 to 5 or even 1 to 3? All right. Keep in mind, raters, you're not rating this thing for the first time. You need to look at the evidence and ask the question, is there sustained material improvement reasonably certain to continue under the ordinary conditions of life and work? And does that examination you're looking at show that? And is it possible that in some of these higher risk reductions like headaches and heart disease, that the examiner is actually explaining that to them, because they're not. Right? And we're going to get that reversed almost all the time. And the last thing I want to say is you cannot take money away from veterans when you reduce them because you're suggesting their disability improved in the severity. I had a hearing a couple of weeks ago. There was the legitimate reduction. They had the vet rated for 10% of a shoulder, the two different codes. They weren't supposed to rate it that way. They had to take one of them away. Wasn't going to change anything going backwards, but it would have changed something had they retroactively reduced it, which they tried to do. And the notification letter said right in the letter, this is likely going to result in an overpayment. I don't know what they're teaching you guys nowadays. A reduction based on improvement or your own error cannot result in an overpayment. The majority of reduction hearings I've had lately is not because I couldn't win the stop the reduction without a hearing. It's because I had to have a hearing to remind VA employees that you can't create an overpayment, but the language that you're putting out there is going to do exactly that. And the way you're keying it into your system in the background is going to send a message to the Debt Management Center, and they're not going to look in VBMS because they don't use VBMS. And they're just going to send out a debt collection letter when there's been no notice of an overpayment. All because you guys are simply not paying attention. Cut it out. Stop reducing people so much, for Christ's sakes.
That was good. It's true. We get very frustrated with it, but hopefully some of the tips I gave you earlier will help you know how to fight them too. I know we're getting close to time, but we're gonna do a couple more. Nate, so if you wanna give us the next question, I'll take it. Okay, this is from Michael Ball. I filed for obstructive sleep apnea, but VSO uploaded DBQ and IMO as one document. IMO not referenced with stated PTS2 weight gain to OSA, claim denied. I filed supplemented, including IMO separately, but denied due to no new evidence. What is the best course? Okay, so we see this a lot when you're filing supplemental claims. And on the rating decision, it says, what evidence did you review? And we see all the time the evidence that we put in is not listed there. If it wasn't listed there, I can see how you thought, oh, this wasn't in the file. So when you filed a new claim with it, they were like, this is the same. We've already looked at this, even though your rating decision didn't say that they looked at it. Your best bet is to file a higher level review, because that closes the window for evidence to be submitted, and you can make sure that that higher level review person reviews the IMO and the DBQ and everything else. So when you file that higher level review, attach a single page on the back that says, you know, my PTSD or my sleep apnea led to my obesity because of my PTSD, or however you want to say that. Here's the IMO that says this. You know, here you go. They should review that letter, and what you'll probably get is either a grant, a denial, or a duty to assist error, where they go and they get another medical opinion on it. But we see this all the time, and I would file a higher level review. That's what I would do. Kerry?
Same exact thing.
Yeah. If it's denied on higher level review, just go to the board after that.
Rashana Moss, thank you so much for your support to veterans. This forum means so much to us. You're welcome.
That doesn't count as yours.
Oh, no.
Another
Okay.
one.
Damn. All right. Step by step 889. Waiting for an AOD motion to be made at the BVA. How long are wait times currently for the AOD decision? and if granted for direct docket lane timeframe. That is hard to answer. We see motions granted anywhere from a month to 5 months. There seems to be no rhyme or reason for that. And once it's granted, I would say usually within 4 months ish. Is a good guess. I mean, that's a little difficult to say as well, but certainly much faster than a non-advanced case. So I would say if you're going to do the motion, if you've done it already, it sounds like you have. You want to make sure it's a standalone motion by itself, so that the board kind of sees it that way. And beyond that, you just kind of have to wait on it. I don't know, Ursula, you have anything?
No, it's kind of the same. All right. Well, thank you guys for joining us today. We really appreciate you coming in and saying hi. I hope we got to some great questions and we offered you guys some good support in the reductions. And someone will see you next week. Thank you so much.
You served your country, and now another challenge awaits. Getting the VA disability benefits you've earned. Too many veterans face endless delays and denials, and they shouldn't have to. At Hill & Ponton, we know the system and how to fight for you. Scan now to download The Road to VA Compensation Benefits, a free guide from Hill & Ponton, trusted VA disability attorneys. For over 30 years, we've helped veterans secure the benefits they deserve. Our free guide helps you avoid common mistakes and know when to call for backup. Scan now or visit hillandponton.com.